This is Legal and Ethical Issues from two different chapters in your textbook, beginning with the legal components for Chapter 7. This is just a little bit of an overview of what, hopefully some adjustments to our schedule for this week going into the next couple weeks so that we can get a little bit more caught up. And I'm recording this today too to have available for if you need it later for study. So I'm going to go ahead and get started. I'm going to do just an overview of legal and ethical issues, talking a little bit about, the standards and what's expected of you as a practicing nurse, how nursing is legally regulated, as well as ethical codes that pertain to our practice, also being considered standards that we have to adhere to. Your textbook has several definitions, and I won't, go discuss each and every one of these because you can clearly go back and review these based on what is on your study guide for the final exam related to this. I have also provided a legal practice quiz in the course. That is not for a grade, but doing it may help you get a better idea of what you're prepared for in terms of what you already understand about legal and ethics. And then also, maybe from looking at how you do on that, get a better idea of what other areas you might want to review in the textbook or in the other materials for Module 4. And these are just some continued terms, some of which we're going to talk about it a little bit more in detail. It's important to remember that in terms of your nursing licensure after you pass NCLEX, we've already discussed about people who are interested in having compact license, but where they're able to practice in more than one state. But it's really important to also remember that there are some jobs that you may have where you're doing practice by distance, and because of that, you're licensed in North Carolina, but you're doing some kind of distance work with a client in Delaware, then you need to have dual licensure. And this also applies to, although it's not on the list, it also applies to faculty who are, if you're ever doing some type of teaching programs, from a, not just like from an in-service standpoint, but teaching from a teaching content standpoint across state lines. Typically, those online universities require you to also, and insurance companies that have you doing case management across state lines also usually require you to be licensed in all of the states that you're going to be practicing in. You all already know that we do have, a council of boards of nursing that overviews, and we have accreditation bodies like NLN or the Commission on Collegiate Nursing Education. CCNE is, of course, the one that we use for our school, but different colleges and schools of nursing are accredited through whichever one they feel best suits the programs that they have in their school. Again, we've talked already about compact state licensure, but one thing I did want to mention about this is make sure if you are ever practicing in a different state, you really, really need to pull a copy of their State Practice Act and look at it. Don't just take for granted, oh, it's a compact state. You need to really, you're going to be practicing in a different state. You are going to be held to whatever their State Practice Act says. So you absolutely have got to pull that and make sure that there are some variations between states, so you really want to make sure that you understand what you're getting yourself into. We're going to talk a little bit about what is a tort, and this is just comes from Old English. in terms of law. You have intentional torts, negligent torts, and liability torts. In your textbook, this is really broken out really well in this diagram. So when you're trying to study for the final exam and trying to kind of make sure in your head you understand those three categories, refer back to this diagram, because whether it's here or in the textbook, either one, it's really kind of a good, easy to see breakdown of things. So again, we want to focus on trying our best not to be involved in a malpractice lawsuit. But sometimes that occurs not just because we're the practicing nurse that's being sued, but because the whole organization is being sued because of a situation, and then nurses in there. The more entities that you can name in a lawsuit that may have contributed to the outcome for a person, the more strength that they have. So what we have to remember is we are held to the standard of what our Nurse Practice Act is, and regionally kind of what is the definition of what a prudent nurse would do, or not doing something that a prudent nurse would not do. And to move a little bit more detail into that, what is some of the differences between a non-intentional tort and intentional torts? Non-intentional are things like negligence, something that was unreasonable that someone did based on someone's definition, and proving that in court in a civil action. But there really isn't something that is criminal or a criminal act or an actual crime. Intentional torts, on the other hand, are actual crimes. Things like assault, battery, false imprisonment, trespassing. Someone died as a direct result of something I did that would be considered more intentional than just malpractice. So how do you prove malpractice, or how do you even bring forth a malpractice lawsuit? You have to have 4 required elements. So you really need to know what these 4 elements are for your own safeguard, but also for testing purposes. You're going to see things about duty, breach, or negligence towards the standard of care, causation, and actual damages and harm. So anytime somebody feels that they've been wronged, or that they believe that they have been put in harm, they may seek to do a lawsuit, and they'll go to a lawyer, and the plaintiff will try to outline what happened to them, and the lawyer will usually ask to pull the records, for the medical records for wherever that care was provided, and they are looking to see if they can establish the person that was taking care of them or had a duty to provide care to them, is very clear that that person who had a duty to provide care breached or was negligent in terms of what the typical standard of care for that profession is, that actual breach or negligent actually was the root of the true cause, or a huge contributing cause to damages and harm that the patient experienced. So someone could have an untoward event and a negative outcome, and they might think something happened or didn't happen that was a standard, but maybe they have a very complex medical condition that there are 4 or 5 other things that could have caused the actual negative outcome. And so those, you could bring a lawsuit, but often those are ones that are dropped or just not further pursued because that linkage of the cause is not very clear. So What the lawyer for the plaintiff is going to do is they're going to hire expert witnesses. That may be expert medical witnesses, that may be expert nurse witnesses, but experts in the same field are going to review, did the nurses have an actual duty that were named on this lawsuit? Is there evidence in the medical records, in the testimony of the patient, the family, of other experts that really conclude that there was definitely a duty? I wasn't just there on the day that this happened, but I was assigned to the patient, or I was the charge nurse for the whole floor, or I came in and I took responsibility for this patient during lunch. Did I actually have a duty? They're going to look at what is the standard of care for this kind of thing. And usually the expert witness needs to be pretty much an expert in that kind of care. So you can't have an ED nurse deciding that an oncology case was done what was the standard of care for oncology. So, your expert witnesses are usually really selected based on how well their background fits with being an expert for that kind of case and that kind of care. So they're going to judge based on their work and their experience in the field, along with any standards that are out there in terms of the hospital policies, the usual accepted way in the Practice Act that we are able to do things, or other standards in literature like an ED textbook, or an OR. What is the standard for a standard case for something? So they're going to use those kinds of things to look at what do they see in the record and the testimony compared to those kinds of standards. If they determine they feel that a breach or that negligence occurred, then that's been met. Then they look at the cause, as we already talked about. And then finally, is there actual damage and harm, or is there perceived damage or harm? And harm has to be more established in terms of, is it long lasting? Is it something that just bothered you for a month or a week and was a normal process of healing? Or was this something that you have permanent damage and harm from? So this is just a little more detail, some of which I've already mentioned. Obligation to really be exercising reasonable care and judgment with somebody. Did the patient actually seek and knowingly, accepts your care? Or were you in a situation where you assumed the care of the person? And was the care actually still going on at the time that they're alleging this event occurred? Or had that care relationship already been terminated prior to some of this occurring? So there's some real details there to be explored as well. Again, a breach or negligence for a standard of care is that which a reasonably competent and skilled healthcare professional with a similar background and in the same or similar community would have provided under the same circumstances. So you're not being judged what someone would have done in Canada. You're being judged what somebody would be doing in North Carolina in that kind of healthcare setting, sometimes even as well. And so basically the professional acted below or outside what that standard of care is. Again, clear cause, and damages in one category another occurred that are proven. These are just some common causes for malpractice suits to be aware of. Delayed diagnosis or misdiagnosis is one of the largest ones, because then people have worse prognoses and they feel like if it had been diagnosed earlier and caught earlier, then a lot of the damages would not have been as severe. Surgical errors still continue to be area of concern. Poor medical case management, people being discharged too early. Nursing gets involved in this sometimes too, because we're giving orders to discharge somebody, and you go in and you're doing the paperwork and the teaching and everything, and you're hearing over and over again this person let you know, I'm not ready, there's something about this that you don't know, my home sitting's not going to be good, I'm going to do poorly because of X. That's a key for you to stop right then and there and go and cover yourself and call the physician and call the case manager and let them both know you're not comfortable with this discharge based on what this person is telling you, and let them intervene and show that documentation, just so that it makes it real clear, I did what I needed to be the patient advocate in this situation, so that if anything does come out of that, at least you have shown that you have followed the correct process. Medication errors are usually a big area of concern, which we know. I've already mentioned this in class when we've talked a little bit about labor and delivery being one of the costlier situations for providing care and financial, on the financial side of things. And part of that is because the cases that do actually win are very, very costly to healthcare organizations, and as well as the medical malpractice insurance that agencies are paying to ensure the best coverage for those kind of things. Here's another thing that just kind of outlines the top 10 specialties for lawsuits. You can see surgery and OBGYN are way at the top, and some surgical on down. So just to give you an idea of, from a medical specialty, what the issues are high in. Main reasons listed: complications from surgery, again, failure to diagnose, a poor outcome or something caused a worsening of a condition, failure to treat, didn't recognize something right, and that delayed treatment and then they had a worse outcome, wrongful death. And then it just goes on down with just kind of the breakdown of what you normally see in terms of reasons for lawsuits. Common clinical practice areas that cause the rise of allegations to malpractice: areas of treatment, communication and reporting. That is one of our huge areas for nursing, because we may see things, monitor things, have a duty to continually communicate not just to the doctor, but communicate back with the patient, as well as reporting concerns readily. Monitoring, observing, supervising, and surveilling is huge areas that nursing are the most involved in. So just making sure that anything that you're monitoring, you're really documenting it well, you're noting your concerns. If you are seeing a negative decline in something, that you're clearly showing that you reported these things. If you're not getting the information from the physician that you need, then reporting that up your chain of command in nursing to your charge nurse, to your house supervisor, or your nurse manager. Unprofessional conduct. These are some things that can kind of come about in terms of legal concerns, where it was somebody impaired on the job or under the influence of a substance. We have also in the workplace the opportunity for horizontal hostility, bullying, physical or emotional violence towards people. So those kinds of things can antagonize a already difficult situation that might occur that's legal, but it also is a legal problem for these kinds of things to be going on in an institution that might be sued on behalf of its workers as well. So this is just a little bit of the rundown of the litigation process. Someone would receive a suit or notice. Then you go through the discovery phase where they request information, records. They do interrogations and get witness testimonies. People are called in for depositions to actually legally be a witness with both sides present in terms of lawyers, and you are grilled back and forth by the lawyer that's on the opposite side. Those are all recorded depositions. So then the lawyers on both sides go back and review those recorded testimonies and determine how they're going to pursue the strategy of the trial, or whether the depositions are so damning that maybe they should consider settling. And so those are just some of the parts of it. If they decide they have enough of a case, they may just proceed to trial, and those same witnesses would actually be put on trial. And then there are, of course, appeals that can be done to the outcomes of the cases and that kind of thing. So these are some litigation do's and don'ts. You always want to make sure you secure the record. So if you get notified that you're involved in a case, you want to call the risk management of where you work immediately and let them know that. They then will work with IT to secure that medical record so there's nothing or anybody is going back in that record for anything. They also will report to the hospital or healthcare agency's insurer, their claims department. They will keep, it's important also to store any correspondence of anything about this claim not in part of the medical record but separate. They will tell you, do not in any way contact the patient or their attorney. Do not discuss the facts. And that's one of the hardest things, I think, when nurses hear, oh, so-and-so or this happened and we're being sued. It's like you want to discuss it and see what everybody can remember about it, and you're going to be called to be on trial and be asked who all of you discussed this with, or even in your deposition, and you have to be sworn under oath even for the deposition. So anybody that you name that you've discussed this with, they will call and depose them too to see if what you talked about has any bearing on the case. So mum's the word, no discussion with anybody about any of it. And the other thing is, do not take notes regarding your thoughts on the case, because they're going to ask you also, do you have any notes related to this case? And if you're under oath, you have to say yes. Then they're going to subpoena those notes that you have as well. There are statutes of limitations that are certain kinds of cases in state law are going to say how long you have before you can bring a malpractice lawsuit. Some states it might be 2 years. Some could be different. For pediatric patients, sometimes it's, until they become an adult. There's different rules in different states about that. So there are statute of limitations depending on the case that it is. They also often will have to develop an affidavit of merit that's really showing the court that this is really a legitimate lawsuit and why. Otherwise, it might not ever be even accepted. And then the different sources of law that they're using to, it has to match up basically with the laws of the state in which it's brought. So nurses can be fact witnesses or they may be expert witnesses. A fact witness may be somebody who was actually part of the situation, who has facts about how this all transpired. And then they can also be expert witnesses if they, you can go on and become certified as a legal nurse expert, and the pay for that is somewhat lucrative. So you may have nurses who are involved in a court case that are actual, defendants, and there to provide facts as they occurred. Or they might not be named in the lawsuit, but they worked during that time period, and they might be subpoenaed to be there to provide facts of the case. And then the expert nurse witnesses are those who review the case for the attorneys on both sides and say whether they believe, in fact, that breaches have occurred, that a cause was there that was definite, and whether there was a duty there, and whether or not the actual damages occurred as a result. We've already talked a little bit about standard of care, but I would just make mention of, do you know the standard of care in the hospitals and the units that you're getting a job in? How does that standard differ from one unit to another, or from one hospital to another? Do we do the same thing at, a smaller hospital as a larger hospital in terms of standards of care? So it really behooves you to protect your license by really getting in there and finding out, what is the standard here, and am I following it? And or is that standard of care that's being done really reflective of standards nationally and those kinds of things? How well would those policies hold up? Here's some documentation do's and don'ts. You've probably heard a lot of that before. The same thing goes with electronic. You can go back in a record after the fact if it's open, or that day later in the day, and, add something to it. But please know that it shows on the back side of that, when they pull the records, it shows when you actually put it in, not that, 2 days later you logged into Epic or Encompass and you put in something extra. It's going to show that was done after the fact. Most of you won't be working with paper charting, but occasionally there are some places that do have things like in offices that are paper. So there are some things just with paper documents, best practice there. And it's really good often if you're having issues with something the patient's saying, to really document it in quotations about exactly what the patient is saying. I do that pretty frequently because sometimes that lets you know how vague or how specific they're being. And it also can help show sometimes their knowledge level is not really what it may, that their words are letting you know that their judgment on this is not really in line with what the medical professionals would say. So just be very, very clear and be consistent with what you're doing with that. Other areas that deal with some concerns legally are informed consent. These days, those are all done by physicians, but sometimes you'll go in to be the witness for a legal consent behind a physician as a second witness that the person did sign an actual consent. And if they do, the patient may be telling you they don't really understand what kind of test they're going for or what kind of procedure they're having done. Don't be a witness to something when it's very clear from the patient's comments that they've been informed, but it didn't take. So that's a good reason when the doctors need to come back and have another discussion with them to ensure that before you sign anything. In terms of healthcare legal relationships, this is something that nursing comes into contact very frequently with. Who has power of attorney if someone is not competent to make their own decisions? And we'll give some examples and talk about this in class as well. But, is there a durable power of attorney? Is there a healthcare power of attorney? Do they actually have a guardian established, or do they have a guardian ad litem that was appointed by the court? Do they have a child that's an adult? And what if there's a whole bunch of siblings that are all adults? Then who is the main one? And so we'll use that as some examples, but always be making sure who really is. Just because someone's there and they're the person that stays with somebody while they're a patient in the hospital or comes to them with their doctor's appointments, that might not be the person who's really their healthcare power of attorney. That might not be the person who legally is their person to give consent for things. So you have to really know what the law is in the state related to that as well. I'm not going to belabor HIPAA. You guys have learned all that you ever want to know about that. Just to keep in mind that the more as electronic ways of providing care are occurring, sometimes there's more ways for breaches to occur. And so that's something that I believe that will be on the forefront going forward, is making sure that really we want to have access and have it really easy to get to, but we also have to be cautious in many different ways to ensure that everybody's health information is protected. And of course, that still goes for talking about these things in public and sharing things with somebody who maybe doesn't need to know about it, and accessing records that only you're really responsible or have a duty to the patient. I always think about this in terms of somebody puts somebody on the bed board that they're going to be admitted to my room, but I haven't really gotten a report on that patient. And so, yes, don't really have a duty to that patient because they're not up on my unit, but I'm looking in their record and getting details and trying to be ready for them to arrive, and then they change them and they're sending them to another floor. That can happen. So just realize, someone might question you from IT. IT does audits all the time about access issues, and so the penalties are very severe. Like, you might get one strike, and the second strike, you're out, you're terminated. So it's not something to mess with. It's just a little bit more about mobile devices, and that's even getting more sophisticated than even what is in your textbook. The other thing to know from a leadership standpoint is you can be held personally negligent as a nurse manager because of something in clinical practice you actually went in the room and took care of. You can be held liable for delegating something or not supervising what you delegated properly. And then you can also deal with the liability of the healthcare organization. Say there is a lawsuit that occurs towards the hospital and it had to do with something in an area that you were over, then you are going to be very much a contact person and involved, even though you personally maybe never even met that patient. So we are all, depending on what level a leader is, they can all be involved in some of that. In terms of liability of healthcare organizations, these are some of the things that you can be sued for. You can have sources of negligence for employees, which we've already kind of discussed. You can have negligence of independent contractors. Maybe you have somebody that you have that's a travel nurse, or somebody that independently contracts to provide some kind of medical equipment or supplies or something. You can also have negligence arising out of the facility's responsibility to hire qualified people and surveil them. So if you hired people that weren't competent, you could be sued for that as well. And then just failure to comply with all kinds of laws and regulations in healthcare. This just kind of talks a little bit more about your responsibilities in terms of, hiring competent people, taking action on things that they do. You do have a duty to train and orient and evaluate them. And if they aren't doing well at something, you can't just keep bypassing that. I mean, if you do, and then that person has an issue, then you can be sued as well as the actual person who was negligent. Again, we have mandatory reporting rules. We have a duty to report to physicians. We have a duty to report. We have a duty to warn. And so we need to realize that if something doesn't go right, you need to keep using the chain of command and keep going up the chain of command until you get someone who is going to hear the severity of something. And you can't really be held liable. I mean, you can't really, you can't be personally liable if you're the one who's doing everything in your power to get something done about it, and they can't come back to you and say, oh, you're just a terrible employee because you just keep, crying wolf or whatever. They could legally be in trouble if they're not following it and you have evidence that you did go up the chain of command. These are some other questions that people often ask. Do I need my own insurance? It just depends on the liability of the area you're in. You might work in an area that rarely lawsuits occur, and it's probably a pretty basic thing, and you have good employees and a good place going on, and nothing ever much comes up like that, then you might not be as worried about having your own insurance. But I will say this, if for some reason legally you have episodes where you cut corners and you do different things, and they know it, the hospital knows it, or you've been written up for something before and now you do it again, and it causes a lawsuit, they're going to, number one, fire you, okay? And when they fire you, the lawyer for the hospital will no longer represent you. So, nor will their insurance necessarily carry for you as well. So, it's not a bad idea to have your own insurance. It's fairly inexpensive. And I've always carried it myself personally. Never had to use it so far in all these years. But just on the chance that something could happen, it just depends on how do you want be carried for insurance anyway. That's really an individual thing. But I do think in areas that are more litigious in terms of service lines, it's probably a good idea. As long as it is ordered by a physician, is it okay for me to do it? If you have to ask that question, then likely not. Because if it sounds wrong to you and a prudent nurse would have questioned it, or a prudent nurse would have refused to give it, and you go ahead and do it, then that's negligence. So even the idea that if you found yourself in a circumstance where you had to ask that, you probably need to stop right there and say, no, I'm not doing this until I get more answers or more information. You can be held liable for the acts of your employees if you ongoingly allowed your employees to do certain things that were wrong and didn't put a stop to it. You certainly can be held liable. And can you be liable for acts of coworkers? Like you and somebody else work a lot together, and if you are aware of their problems and you just kept them to yourself, you could be liable because you knowingly were allowing something incorrect to go on. So putting yourself first legally is an important thing. And the last question, am I required to report illegal patient activities? Absolutely. The faster you can, the better. Closing thoughts. Just remember that juries make their decisions first and foremost on their evaluation of the individual before them. Issues of character trump all other presumptions. Presuming the medicine is sound, the practitioner who passes the character test will be given the benefit of doubt on his or her medicine. This is just a quote that lets you know how you are perceived in terms of your character as a professional nurse trumps everything else. It is very common that even a nurse who made a mistake, who went and said that they've made a mistake and they are very sorry and what can we do to make it up to you, might not ever even end up in court. It's really about what they perceive you to be. If they perceive you to be lazy, aloof, non-communicative, incompetent by the comments you make, either during the events, all those things have a significant play. So keep that in mind in your interactions with your patients to be best safe. All right, I'm going to continue on, and there's just a few more slides about ethics. And I know you've heard these terms probably. Autonomy is the right of self-determination and freedom of decision-making. Benefits is doing good for clients and providing benefit balances against the risk. So really doing the best you can against what the risk involved is. Non-maleficence is doing no harm. That's one of the big things in medicine is first do no harm. And then justice is being fair to all and giving equal treatment, including distributing benefits, risk, and costs equally. So those are key ethical terms with any ethical dilemma that a group would use to kind of determine what is our best action given us an ethical dilemma. These are some other ethical terms. Fidelity is loyalty and faithfulness to commitments and accountable for responsibility. Veracity is telling the truth and not intentionally deceiving or misleading clients. Confidentiality, safeguarding their information. Privacy, right of limited physical or informational inaccessibility. So in other words, privacy of their physical being as well as their information. And just to be aware, sometimes you're going to have ethical situations that occur in hospitals. Many of you have already seen some of these examples in clinical already. But hospitals, if they're Joint Commission accredited, typically have a process by which they handle ethical dilemmas that occur. They're required to for accrediting purposes. Some of those will be in the form of an ethics committee. And an ethics committee will be made up of people like clergy, social work, a physician, nursing staff, maybe a psychologist, just a broad base of different disciplines. And they may call together that group based on a call chain anytime that an ethical dilemma is brought forward. And so it's pretty common that the process would involve, if nursing or physicians or anybody that's working with patients in a hospital determined there was an ethical issue, you need to take it to your leader first thing. And then they are going to immediately contact the correct lead person on the ethics committee. And usually a lot of them will have that ethics committee meeting within a 24-hour period of time. You know, they'll call people in that are on call on a weekend if they have to have an ethics committee meeting. Some places will use what's called a narrative model, and is becoming much more common. You know, we talked about some of those other ethical terms that are used to kind of determine what is this the best for everybody involved. You know, like they use those concepts to make to do questions around the circumstance. But more and more they're using narrative, which means that they might invite the patient, the family member, different people to come to the committee meeting and actually discuss their concerns. Or if they want to do it more on a trial basis, people who are on the committee may take on the role, say, I'm going to take on the role of the patient. So when I come to the committee, I'm going to speak as if I'm coming from their perspective. So it's just a model that is not like a lot of outsiders looking into a complaint, but almost some role playing around how those viewpoints might be very different, and how to best acknowledge and make actions based on a true picture of the whole situation. But anyway, please know that you'll hear about that in orientation to the hospital. Make sure that you know what that mechanism is. So ethics can be clinical practice ethics, which you think about at the bedside. They can also be organizational ethics. Maybe there's some kind of thing that goes on in the healthcare operation of that organization that is unethical or unsafe or, problematic legally or ethically. And so there's, ethics occur not just at the bedside, but can affect you as an employee. There are some things that are ethics related that are a professional responsibility. For example, as a nurse, we may see another nurse who is impaired. We have a professional responsibility to report that. So we are going to ethically have expectations at the clinical level, at the organizational level, and at our own professional level, depending on what profession that it involves. We, of course, have a code of ethics. You've heard about that since you became in the nursing program. So just realize that that's a pretty easy document if you're having an issue with ethics to go back and say, how does this relate to this situation? There's some guidance there for nurses. And this is just a list of those and what all is expected. So take time, if you can, to read through those and just really acclimate yourself to what are those as you go out into practice. In terms of your own responsibilities, if there's a conflict of ethics, you can't remain silent. You have to take that to the next level, whether that's your charge nurse. Then if that doesn't feel like that's resolved or they don't see it the same way, but you still feel there's an ethical situation that needs to be reported, go to your nurse manager, go to the nurse supervisor. If it's on the medical side, you could certainly speak to a director over that medical service, but often your nurse leader will handle that if you give that over to them. You have a duty to report any kind of ethical situations that come up, and particularly those that have an impact on good patient care, There's a code of business ethics, like so that things are, people are not being financially negatively impacted about something that's unethical. Billing practices, as we talked about with finance. So a wide variety of things that can occur, but those decisions really need to have that mechanism in place for making the most ethical decision. Just some trends your textbook talks about. We know that nursing staffing shortages can become a serious issue ethically for people, not feeling like you can provide adequate care. Also, how definitions of families and who all really has say-so and involvement is ongoingly changing. And then confidentiality versus public health. We've seen that with the pandemic in terms of what is really public and what is really private. So there are conflicts of ethical things that revolve as the world around us and the care environment changes. These are just some other elements that go along with short staffing. Just not that that's anything new to you guys, I know. So ethics is knowing the difference between what you have a right to do and what is the right to do. So it's knowing not just, I should have a right to do something, but what is the really right thing to do in that situation? So it's not based solely on your own perceptions, but like all the people that are involved within that situation should have some way to participate and provide more information so that we really do the right and best things for people. And this is another quote: to do what nobody else will do, a way that nobody else can do, in spite of all we go through, is to be a nurse. So I will end this on that thought. And in class, I hope to spend some time with you guys about some actual elements of this and get a better idea of what all you need to be prepared to handle.